The following program is classified G. It's suitable for all ages.
Tonight, we look into the Prevention of Terrorism Act. Sri Lanka's current government has made it clear that security is of paramount importance, and as a result, the country has witnessed some of the most secure years in existence. This has been credited to legislative mechanisms such as the PTA, which is strict on acting against terrorism, the provisions of which have come under scrutiny, but prioritizes efficiency, which is crucial in addressing terrorism. It is important to note that Western powers, who are the biggest advocates of human rights, have absolutely no tolerance when it comes to terrorist activity. These signs are witnessed by historic cases of invasions and legislative actions such as the Patriots Act within the United States. Is Sri Lanka being dealt with an unfair hand in being asked to reduce its legislative action against terrorism? How does the PTA work to curb terrorism within Sri Lanka? Welcome to Law, Land and Liberty. We are going to discuss the Prevention of Terrorism Act within today's program. In approaching this specific subject, we have an individual with us today who has a grand amount of experience in this field and an experience within the legal field as well. The 25th President of the Bar Association of Sri Lanka, President's Counsel, Kalinga. Indatissa. Thank you so much, sir, for joining us. In approaching this topic, we are going to go into 4 key areas. Firstly, the offences that are identified within the Prevention of Terrorism Act. Secondly, on the authority of investigative officers. Then we're going to talk about the freedom of expression and the questions that have been raised within that regard. And finally, the distinctions in the PTA and the general criminal offences.
Hi, my name is Sivana Hemara. I'm an electrical engineering student. My question today is regarding the offences identified in the PTA. What are the offences identified in the Prevention of Terrorism Act?
All right, sir. Once again, thank you for joining us and giving us this time. Let's directly go into the discussion. I believe you have spent a lot of time, a lot of academic time within this field as well. My first question, sir, just to clarify for the laymen who are watching this program, what are the offences that are identified within the Prevention of Terrorism Act? And then we'll move on to if there are any subsidiary acts or legislature that supports it.
No, actually, the Prevention of Terrorism Act number 48 of 1979 was introduced in July 1979 by the Parliament at that time. Basically, when you examine the preamble to the law, you will find the reason for the introduction of this act was, number one, the penal code and other criminal legislation in this country at that time was insufficient to deal with situations arising out of so-called acts of terrorism. Secondly, in various different other countries like England and several other countries, specific laws had been passed, and in drafting this, the Parliament took into consideration some other legislation which existed in Singapore and especially the United Kingdom. Now, what are the offences under this Act? Basically, sections 2, 3, 4 and 5 of the PTA deals with the offences. PTA, it is relevant to note, was passed as a Temporary Provisions Act. Even now, the title of the law reads as Prevention of Terrorism Temporary Provisions Act. So it has been there in existence since 1979 for the last 42 years. Now, Section 2 identifies a series of offences which deal with circumstances and situations which may arise when terrorism is looked at. Unfortunately, the statute does not define the act of terrorism. It defines unlawful activity in Section 31. But the very definition of a term terrorism is not found there. So in the absence of such a term, we may have to look at it from the dictionary meaning. Generally, from a dictionary meaning, it is defined as the unlawful use of violence and intimidation, especially against civilians, in the pursuit of political aims. Now, based on that, the main offences are found in Section 2. Now, if you go to the Act, you will find there is, you start with death or kidnapping of a specified person. A specified person is identified in terms of the law.
Yeah.
Maybe a member of parliament, a person holding office, a judicial officer, or any member of the forces. A specified person, abduction, death or killing. Then there is death or kidnapping of abduction of witnesses. A person who is a witness to a particular offence, if he is abducted and disposed of, that is also an offence. Then you have intimidation. Intimidation has the same meaning as the penal code. And also you have robbery and theft of public property, mischief in respect of public property, importation or manufacturing of firearms, then also possession of without lawful authority any offensive weapons or firearms, racial and religious disharmony. Now that section is referred to as section 21H. That is the most common section that the prosecution and the investigation generally use to arrest people. 21H. Okay. Then there is without lawful authority who erases, mutilates, defaces or otherwise interferes with any words appearing on any board. And also harboring or concealing. Those are the offences introduced under section 2. Then in section 3 you will find the offences of preparation, abetment, conspiracy or incitement. That is, if anybody makes an effort to abet an offence or conspires or incitement of any of the offences in section 2, that also becomes an offence. Now, abetment under the penal code is where you help a person to commit an offence. Same concept is incorporated into this law, and it is made the separate offence under section 3. Then under section 4, section 5, before I come to section 4, I'll have to deal with section 5. Section 5 says, if any person fails to disclose information that any other person has committed an offence or is involved in the commission of an offence. Now, if I know that somebody is collecting firearms for the purpose of terrorism, if I know that somebody has committed an offence under the Prevention of Terrorism Act, under section 2 or section 3, if I fail to disclose that to the authorities, that is an offence. That is called failure to disclose information under section 5. Then, for all these offences, there are very serious consequences. One thing that you must remember is, why was this introduced? It was introduced because of the various problems which was created in the north and the east by the LTT and other similar organizations. It was not only the LTT. When it started in 1970s, there were several other groups, EPRLF, so on and so forth. Now, all these people were motivated towards destroying public property, burning of transformers, burning of buses, killing of civilians, killing of specified people, that is identified people. And thereafter they proceeded on a rampage of certain activities where the government was compelled to come out with a law. The necessity of such a law would arise in any country when violence is resorted to by people who would be involved in such activity, identified as with the objective probably of some political conflict. So, the main offences are identified under section 2, section 3 and section 5. And one of the most important sections is section 4, which is generally overlooked or not referred to. That is, section 4 identifies, in addition to the punishments which are specified in section 2 and 3 and 5, property of a person who is convicted could be forfeited. That is considered as proceeds of crime. Property means movable, immovable. Both can be confiscated and forfeited. So that is the basic outline of the offences.
All right. Just to get an initial clarification, I believe I witnessed this line somewhere. This act would apply to citizens of Sri Lanka or any individual within the country that commits crime that is identified?
No, it is, if you go by the recital to the law or the preamble to the law, it applies in respect of any person.
Right.
Irrespective of the fact whether he is a citizen or not. Whether the act is committed in Sri Lanka or outside Sri Lanka. If the offence is committed even outside Sri Lanka, if you go to the preamble, if the act is an offence within the meaning of sections 2, 3 and 5, you fall into that category, you can be dealt with.
All right. My next question is going to be now, since this has become a contentious subject these days, where do we draw the distinctions between a normal individual, the general criminal offences that have been taken out, and firstly, are there any other ways we can distinguish that this is a crime under the PTA, this is generally what is considered under criminal offence? Because is it vague in those scenarios, or is there a clear way of distincting and identifying properly?
In order to answer your question, I must refer to the objective of the law. Now, what is the purpose of this law? The purpose of this law is to deal with people who are involved in acts of terrorism. I told you that the definition is not there, but unlawful activity is defined in section 31. Unlawful activity, whether done within Sri Lanka or outside Sri Lanka, people can be brought under this act. But there is a question. Now I refer to 21H. 21H is the most common section which is being used by the prosecutors and the investigators to deal with people. That is, 21H is by words either spoken or intended to be read, or by signs or by visible representations, or otherwise causes or intends to cause commission of acts of violence or religious, racial or communal disharmony, or feelings of ill will or hostility. It's a very wide section. So first thing is, there is ample case law where the superior courts in this country have decided you can't use the PTA to arrest a person who has committed an offence under the normal law. No, the arresting officer is responsible. Now, there is no difference in the concept of an arrest when it comes to an offender under the normal law or the PTA. The initial point in which where an arrest is made, the concept is the same. The difference is the detention and the period of detention.
Yes, I want to delve deeper into that. We'll do that in our second segment. A very, very good context given to us by President's Counsel, Kalinga, Indatissa. Thank you, sir, for giving that perspective. We'll take a very short break and join us back again on Law, Land and Liberty.
My question is about the authority of the investigative officers. What are the powers awarded to the investigative officers to the PTA?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel, Kalinga, Indatissa. Sir, my next question is going to be on investigative officers. And I think I interrupted you when you were explaining and you were going into that field as well on on a clear distinction, and that is, I think, the most contentious point within this, how detention works and the rights for investigative officers to detain or to arrest or even to keep it in remand custody. Could you give us a clarification there, sir?
Yeah, now all laws are subject to the Constitution, whether it is the PTA, the Penal Code, the Criminal Procedure Code, where all the police ordinance, all are subject to the Constitution. Constitution is the most supreme law. In terms of Article 13(1) of the Constitution, it is stated that no person shall be arrested unless you do so in accordance with the procedure established by law. Article 13(2) says that no person shall be deprived of his personal liberty or individual liberty unless you do so in accordance with the law. That is the due process. That is what we call the due process. Now, in the ordinary situation, when a man commits an offence, he can be arrested.
Yes.
But sometimes I find that the concept of arrest is misused. Especially if you go, a person is arrested, how can a person be arrested? The provisions of the Criminal Procedure Code would be the provisions which would speak about the arresting of people. In section 23, a person can be arrested, and section 32 of the Criminal Procedure Code says how a person could be arrested. There must be a reasonable complaint against him. So the law doesn't change between PTA and
I was just going to ask the question whether when it comes to the PTA, are the rules different?
No. Basic initial concept of arrest is the same. Okay. Reasonable complaint, credible information, or reasonable suspicion. Now, reasonable suspicion is where people have to be careful. there is a wide authority which is given to an arresting officer under the normal law as well as the PTA. There is enough and more judicial authority which suggests that the arresting officer must form an objective opinion. Just because somebody sends a petition, you can't arrest a person, whether under the normal law or the PTA. There must be credible information coming to him, or a reasonable complaint, a specific complaint should be made, or when there is no such complaint or credible information, then the third and the widest authority that is given under Section 32 is to arrest a person based on reasonable suspicion. Whose suspicion? It can't be a minister's suspicion. It can't be a politician's suspicion. It can't be the suspicion of an enemy of that person. It has to be the arresting police officer's suspicion. And no other way a person could be arrested, whether under the normal law or the PTA. Now, that is the most important thing. It has been found. Now, terrorism is terrorism. I am totally against that. Terrorism is terrorism because terrorists would not know the difference between ethnicity, race, community, language, religion. They won't recognize. Terrorists are terrorists. So, in the larger interest of a nation, terrorism has to be defeated. In Salus Civitatis Suprema Lex, that is, security of the state is of paramount importance. Now, in that context, the PTA introduced some good provisions, but the question is the enforcement. And a lot of people are complaining, a wrongful arrest. I have experienced that myself. And there is a misconception among every state, every government, I believe, that lawyers appearing for these people are also involved in actors. No, they are only doing their duty by the rule of law. So you can't, you have to appreciate the fact that their duty is only a professional's duty. Now, one of the biggest problems I see in this mechanism is the enforcement. You are given power to arrest, very wide power. You must be careful in how you exercise that power. Time and again the Supreme Court has held in this country, this arrest is wrong because you did not have reasonable suspicion. You could not have had, because you must furnish the material. When then the initial point is you are arrested. Then in normal law, you have to produce a suspect within 24 hours. It can go up to 48 hours.
There is a provision within PTA.
But within the, normal law.
Normal law.
But as far as the PTA offences are concerned, you have to produce him within 72 hours.
Okay.
Unless you have got a detention order. Now a man is taken into custody. First step is it must be based on reasonable suspicion or credible information or reasonable complaint. If it is reasonable suspicion, the arresting officer should inform the material to the next superior officers. The power of issuing a detention order was originally vested with the minister, now it's done by the secretary. It has to be brought to the minister's notice that this man would be required for further detention. Then the material on which he is required, we have done these investigations, it reveals of his involvement, and therefore we need further investigation which is reasonable. Now if there is some element which is coming out from the initial investigations done within the first 72 hours, and he is implicated in a larger plan, that is reasonable for any police officer to ask for a further extension.
Yeah.
So in that context, a man is arrested, he has to be produced within 72 hours, or you have to get a detention order for his detention. If you get a detention order, you don't have to produce him before a magistrate's court.
Okay.
That is the arrest and detention procedure.
Right. Just to get a quick clarification there, the competent authority, where you mentioned three, I think, pillars that they would under, finally being whether there's objective reasoning to arrest this individual, that competent authority is the arresting officer.
It should be the arresting officer's suspicion, no one else.
No one else.
Now, if you are a police officer working under me, I can't direct you to arrest him because you must form in your mind that reasonable suspicion. Otherwise, you must say you can't. Very few people say you can't. That is why when it's tested in the Supreme Court, you will find that the arresting officer did not have material to arrest. So therefore it is declared as a violation of fundamental rights under 13.1 and 13.2. That is how it happens.
Yeah, you may continue that line of thought also, sir. One clarification that we would like, are there any other places where arresting officers have powers exceeding that of the normal authority when it comes to terrorism-related cases? Either maybe not in the PTA, maybe somewhere outside. When it comes to, if it's a suspicion of terrorism, do they get anything else as segue?
Sri Lanka was under emergency since 1971. A lot of people don't realize this. From 71, it was continuously under emergency. President Ranasinghe Premadasa, His Excellency Ranasinghe Premadasa, lifted that emergency in 1988, June, 23rd of June, 1988. Then it was lifted for about 3 months. Then reimposed again. Then thereafter, I think President Sirisena lifted the emergency for a period until the Digara incidents took place. Reimposed. Likewise, so when under the emergency regulation, there are similar powers, something similar and parallel to the provisions of the PTA. But the PTA, you know, this concept of any statute in any part of the world dealing with terrorism is considered a special legislation. You can't complain about it. You know, you can't complain about it because it will be different to the normal law. But the problem is the enforcement. It's not a problem with the law. You know, when a person is arrested, as I told you, normal law requires him to be produced within 24 hours. There is an extension of 48 hours, you can. Under this law, you have to produce him within 72 hours. You don't have to produce him if you get a detention order. Now, who issues the detention order? It's the executive who issues the detention order. On what material? On the material furnished by the arresting officer. So the arresting officer must furnish material to justify that detention. He can't just say there is information that we are required. He must be able to justify. If he justifies, then there is nothing wrong in issuing the detention order. If it is, then the detention order is issued. It is issued for a period of 3 months and up to a period of 18 months originally. So that is how it goes. So as to the answer to your question is, it must be the person who signs the detention order should not sign the detention order unless material is provided to him by the arresting officer that any further detention is necessary. That will be a violation.
Right. Again, a very good description and understanding given to us, sir. We have to go in for a short break. Before that, we have our special segment, that is Law in the Land, brought to you by Anuradha Wickramasinghe, where she will give you a breakdown of the legal news within this week. Here is Anuradha Wickramasinghe with Law in the Land.
Thank you, Danidu. Let's take a look as to how the law has worked in our land. A special discussion was held between the Minister of Justice, President's Counsel Ali Sabri, and Minister of State for Local Medicine Promotion, Rural and Ayurvedic Hospital Development and Community Health Cicero Jayakodi at the Ministry of Justice on the implementation of the Code of Law in compliance with the provisions of the Ayurvedic Act. The discussion also touched on the regulations for drugs and drug production. Prime Minister Mahinda Rajapaksa has instructed the legal draftsman to draft legislation to provide appropriate protection to the employees of public and semi-government institutions for the actions taken in good faith in the performance of their duties. The Prime Minister gave these instructions during a discussion held at Temple Trees on providing relief to public and semi-public servants who have been subjected to political victimization. Another discussion on the impact from the MV Express Pearl fire and receiving compensation covering all areas related to the damage was held at the Ministry of Justice under the patronage of Justice Minister President's Counsel Ali Sabri, Minister of Ports and Shipping Rohita Gunawardena, State Minister Kanchana Wijesekara, Leader of the Opposition Sajith Premadasa and Attorney General President's Counsel Sanjay Vijay Rajaratnam. Subsequent to the discussion, the Minister of Justice, addressing a media briefing, said that they had discussed the compensation received so far and the rest of the compensation to be obtained. The Ceylon Teachers Union filed a fundamental rights petition in the Supreme Court, seeking a declaration that attempts by police and health authorities to prevent protests using quarantine regulations violate people's fundamental rights. The petition had been filed by President of Ceylon Teachers Union, S. Priyanka Fernando, naming IGP Chandana Wickramaratne, Director General of Health Services Aseli Gunawardena, Health Minister Pavitra Devi Vannayarachi, and the Attorney General as respondents. The Attorney General gave an undertaking to the Supreme Court that Samagijana Balawege parliamentarian Harin Fernando will not be arrested until September 1st in connection with the Easter Sunday terror attacks. Member of Parliament Harin Fernando had filed a fundamental rights petition in the Supreme Court seeking an order preventing police from arresting and detaining him in connection with the Easter Sunday terror attacks. That was a look at the major events of how the law had worked in our land. We will now go in for a short commercial break. Danigal will be back after the break.
And I'm a law student. My question is about freedom of expression. How is the freedom of expression dealt within the Prevention of Terrorism Act?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Kalinga Indatissa. Our next segment, we wanted to go into freedom of expression and really talk about the other aspect of all of this, the people that are arrested and the kind of rights that they have, and whether the PTA has any concerns when it comes to expression. However, again, I had to interrupt you when you were explaining something, sir. I want to ask you just a quick clarification about two clarifications. Which court should, once an arresting officer does, in fact, arrest someone of suspicion, which court should they go to?
In terms of Section 7 of the PTA, when a person is arrested, he has to be produced before a magistrate's court. Now, magistrate's court is the original structure. You have to be produced him in the magistrate's court.
Following that, sir, what is the time period in which the person can be kept arrested under the PTA, and how should charges be filed? Because this is a bit of a confusing scenario. If you could explain that to us.
Now, a person is arrested. That is the commencing point. He has to be produced before a magistrate within 72 hours. He is produced before the magistrate. That means investigations have been concluded, or up to a point he is produced. Then an application can be made by a police officer not below the rank of a superintendent of police. I want this person detained until the conclusion of the trial. That application can be. That means preliminary investigations don't show that much of acts of terrorism being committed by this person, but still there is room for investigation. The whole idea of producing a suspect under the normal law PTA is to exercise the judicial supervision on the arrest of that person. That means his detention is not protracted. The court plays a supervisory role. That is the whole idea. In every judicial system, that is the idea. So now, I am arrested, I am produced 72 hours, within 72 hours. Then, if there is an application by a police officer not below the rank of a superintendent of police, keep me in remand until the conclusion of the trial. The magistrate has no option but to keep me in remand. Like ordinary case, he can't use his discretion. But then, in terms of Section 7 proviso, the Attorney General can step in. You can make a request to the Attorney General. The family, through a lawyer, can make a request to the Honorable Attorney General. Honorable Attorney General can grant sanction to release me. Then I will be released. It's not bail. The word bail is not mentioned there. I'll be released. Then the charges will follow. Otherwise, what will happen is, I am arrested. They don't produce me under Section 7, within 72 hours. Why? Because they have got a detention order under Section 9. So after I am arrested, if a detention order is got within that 72-hour period, you don't require me to be produced. I am held in a place of detention. Periodically, the DOE's detention order is issued for a period of 3 months. It can be extended up to a period of 18 months in the original law. So, every time it lapses, the arresting people and the investigating people will apply to the relevant authority, please extend it. Likewise, the extension goes. Now, there are some investigations. Now, say for example, if somebody burns a transformer, the only thing is to find out whether this is a transformer, whether it has been burnt, and whether it was burned by me, that person. Of course, there could be further involvement of that individual in acts of terrorism, which requires further investigation. So depending on the nature of the investigation, the time frame would differ. But now, if you are talking about the Easter Sunday bomb attack, Easter Sunday attacks, if you take that, that requires a lot of investigation for this reason. It is connected in several ways, and that could take months. So you can't, it depends. I will answer your question. Number one, you don't have a definite time to conclude the investigation. That is a problem. There must be provisions which should come into the law which says after a particular period a person has to be produced. Now what the production takes place under Section 7 within 72 hours. There again, if a superintendent of police files a certificate saying that I want him detained until the trial, that is reasonable depending on the investigation and the things that they have to do. But the magistrate is functus, he can't do anything. He has no power. But the Attorney General can step in and grant the power to release him. So he will be released, he will go home, the proceedings will go and the charges will follow. There is no specific time. That's the other issue that I would like to talk, because there is no permanent time or a fixed time in law giving people to conclude the investigation. In fact, there is nowhere in the world there is a time like that. You take the English Act in UK, Terrorism Act, there is no limit.
So I want to give you enough time to talk about this within our last segment. Before we get into that, let's just touch a bit on the, I believe it was in the third part of the Act that we discovered this about freedom of expression and how that limitation is provided, or that is, what do you say, it's put under sort of microscope within the PTA. How do you see the freedom of expression playing out within the PTA? Is it limited to a certain extent, or what is the mechanism through which it's sort of like mentioned, okay, these are the things that cannot happen when it comes to expressing or publication, things like that? How does the PTA explain this?
Freedom of expression is recognized under Article 14 of the Constitution. Everybody can express their opinion. Expression is that. But I must tell you, the freedom of expression is not an absolute freedom. If you look at Article 15, there are certain restraints or there are certain restrictions which could be imposed. But to voice your opinion, there cannot be a problem, there should not be a problem. Voice what you feel, there cannot be a problem. Voicing something which falls within the ambit of this law which makes it an offense is the problem. So otherwise, now if you take, for example, if you take social media, look at the language that people use. Look at the hatred that they spread, right? People are divided by ethnicity, race, religion, right? This is not something that should be happening at this time of the world, at this time of the... Exactly. So therefore, my answer is freedom of expression. Actually, if you look at part 3, you will find about publications.
Yes, publications.
Part 5, prohibition of publications. You can't now, if I advertise something saying about a tuition class, I can't be arrested at the PTA. That has happened in the past. Okay. I can't be arrested at the PTA. That is why I said the arresting officer must know whether if I am with a leaflet, a document, a newspaper, a book, pamphlet, it should reflect something to do with what is there in Section 2. That is why 21H is very, very wide. 21H is very, very wide. So, if you are now, say, for example, if I am arrested with a book concerning Lenin or a leftist, I can't be arrested under the PTA. To think differently is not a crime. But if you try to put down your thinking into actions of a violent nature, violating Section 2 and 5 and 4 and 3, then it's a crime. So what is prohibited here, what the pamphlet or the document that we are talking about under Part 5, what is prohibited is if I give you a leaflet inciting you to burn public property, to fight for a separate state, to fight for a separate area for people, or to get committed to acts of violence, that is wrong. That pamphlet, I can be arrested. Not anything else. Now say for example, all of us during our youth, we have our feelings, no? Right, in criminal law, I always say this, You cannot control your feelings, but you can control your conduct. The moment you don't control your conduct, it becomes an offense. So, what I would, in answer to your question, what I would say is this. This part is there in part 5 cannot be misused by the law enforcement authorities to arrest each and every person, because there is definitely it cuts across freedom of expression. Article 14 is violated. So, all what I want to say is this: freedom of expression is very important. People should be free to express their views. But it cannot border on inciting people to take to violence or to meet what is prohibited under Section 2. Then it becomes a document or a pamphlet that can be taken into consideration in terms of Section 14.
Right. That's a very good explanation there. A small clarification that I want to make is within our second segment, you mentioned now, if the person does feel that their freedom of expression has been violated, or it has been, I think you brought this topic up to talk about the arrestee side. Which authority do they go to? Once you mentioned it was the Attorney General that you should petition to, if in the event there is in the event you want to receive not bail actually to be removed. In the same way, what are the authorities that you should move to in that case?
There are two actions now. Say for the Attorney General is that particular decision on the Attorney General to release persons who have been produced before a magistrate is under Section 7. So generally, in my opinion, even though it does not happen, the Attorney General should have a separate branch dealing with these PTA matters, whereby there is supervision by the Attorney General. Also, man is produced within 72 hours. Some Superintendent of Police applies for further detention. That file should be referred to the Attorney General. Attorney General should take a decision whether he should be discharged or not. Otherwise, that man will languish in jail for a long period of time. Then the other thing that you can do is, if you feel that your arrest is not justified, if you feel that you have been falsely implicated, or if you feel that you have been arrested for political reasons, or if you feel that you have been arrested for malicious grounds, or because the arresting officer does not like your face without a legal basis, if the arrest has been made on that basis, you file a fundamental rights application in terms of Article 13.1 and 13.2, read with Article 17 and 126 in the Supreme Court.
Right. I think a very good explanation there. You clarified a lot of doubts that you and I have been having for quite some time. We'll take a very short break and join us again on our last segment of Law, Land and Liberty.
Hello, my name is Sarah Fernando and I am an IT student. My question is about the distinctions in the PTA and general criminal offences. How are the offences in the PTA different from the general offences?
Welcome back to Law, Land and Liberty. This is our last segment. We are in conversation with President's Counsel, Kalinga, Indatissa. Sir, our last segment we left it out to talk about distinctions between PTA and between criminal offences, because the contentions that has been going around is, now people are arrested, they're kept for a long time. What is the reasoning behind this? Whether it is legal, which authorities they can go to. And you were explaining that and really unraveling a lot of the issues that we have been having for quite some time. I want to ask you, the follow-up is going to be on how international community has responded to terrorism. But before that, if you could tell us, when it comes to general offences, can a person, a party that is being arrested, mention or within courts fast track this process by mentioning, okay, look, this is not something that should be falling under the PTA? Where does that first initial hearing take place? Because if we are to allow, if the PTA does allow investigations to take place for a long period of time and the person should be detained for that period of time, that question does arise, and it has arisen within the public forum as well. How does that person make that argument? Where does that person go in order to make that argument?
The argument is in Section 13 of the Act. But before I come to Section 13, to explain this to layman, let me tell you this. the most important thing for a nation is the security of that nation. That is why I use the term salus civitatis suprema lex. Security of the state is of paramount importance. No person should be permitted for whatever reason to damage and destroy the ordinary civilian life of people. So obviously when there is a group which will try to do that, retaliatory action has to be necessarily taken. There is no question about it, to maintain the balance. But what has happened is, if this retaliatory action becomes attractive to some people for whatever reason, then the entire concept is lost. You can curtail a rebellion or a process, but in the lawful way, not illegally. So, having said that, in an ordinary situation, what happens is a person, under the ordinary law, when a man is produced before a court, he can complain to the magistrate of his reason. But unfortunately, in view of Section 7, being a very stringent provision, there is no provision for him to do anything. When you are produced before the magistrate, only option that is the magistrate is powerless to grant bail. Only option is to interview. The answer is there if Section 13 is reactivated in the correct way. There is an advisory committee. There is an advisory committee which is called the advisory board.
Right.
So every time, whenever people are arrested and produced before magistrates, if the details of this advisory committee, if the details are sent to the advisory committee,
yes,
they can periodically review this and release people whose detention are no longer required.
Right.
If you want to charge them, but don't incarcerate them. Similarly, the Supreme Court plays a supervisory jurisdiction when a person goes in terms of Article 13.1 and 13.2 of the Constitution. So, whenever a complaint of fundamental rights violation is made, the Supreme Court will take notice of that it has done, and it will continue to do. It will identify, yes, in these circumstances he could not have been arrested. His detention is not lawful. And several occasions, the Supreme Court has provided relief to the petitioners. My thinking is, in any country, laws dealing with terrorism have different method of being interpreted rather than the ordinary law, because it deals with a social problem, it deals with a social menace, it deals with violence, it deals with democracy on the one hand, overthrowing of democratic processes on the other hand. So in that context, you take the law in England, 1970. What happened? They introduced the Terrorism Act in the 1970s because there was a problem, the IRA issues, right? But the danger is this: you can't misuse that law to arrest innocent people. You cannot, in the guise of arresting people under the PTA, you can't keep people in detention and after 3 months release them on the basis we don't have any evidence against you. That is wrong. For that, our legal mechanism does not have any provision to remedy or compensate that person.
Who has been arrested without charges, is it?
Without charges. Without charges. Now, if the charges are proven, he will be convicted, he will be sentenced, and the consequences are serious. But otherwise, sometimes this law has been misused in the past. There are occasions where the law has been misused at the whims and fancies of individual officers. But by and large, it is my view that this is not being misused, by and large. So, you can't take this in isolation. You have to understand the seriousness of terrorism. The fact that terrorism will not identify between a Sinhalese and a Muslim and a Tamil and a Burgher and somebody else. There is no discrimination. The terrorists don't discriminate among races or ethnicity. Then you identify as a civic-minded person, terrorism has to be curtailed in the proper way. If somebody has got involved, that is wrong, as in other cases. Then provisions should come into operation. But the problem here is misuse. If the provisions are used to arrest a person who has not committed an offence, it's a great sin. If the provisions are used to keep person in detention without supervision, that is also a great sin. So therefore, I think the Attorney General and the Advisory Committee and those who are responsible for executing these orders, detention orders, review of detention orders, they should take responsibility in forming themselves into a group to periodically review these cases. Then only the courts will not get inundated. No one is going to complain of inordinate delay. No one is going to complain of incarceration. That is the only answer.
Right. I think the answer provided a good solution there as well. So, given the kind of brilliant contextualization you have given all throughout the questions that we have put to you, I want to ask you this as sort of like towards our ending segment about other countries. Now we see the Patriots Act, which was also contentious within the United States. We see even the United Kingdom taking very strict measures. Their leaders are very strong when it comes to defending their troops. Terrorism is a serious subject in these countries, and they take it quite seriously. How are these countries dealing with it? Are they so different to the PTA that is functioning within Sri Lanka, or is it something similar? Where do you see the irregularities?
All what you need to implement a law of this nature is sanity. Whether it is in the United Kingdom or otherwise, any country, you need sanity. You have to be reasonable and you have to have a rational approach. You can't abuse power, you can't not use power. Both ways, right? Now we all know from in a general context, if somebody says, I was aware of this but I did not take any action, there is liability. It goes both ways. You can't abuse or misuse both, or not use. So what I would suggest is, if you look at the example in UK, they are very strict. On the one hand, the Prevention of Terrorism Act is very strict. On the other hand, the courts will respect the rights of individuals. So here, man is arrested, investigations are expedited, there is supervisory jurisdiction in respect to the investigations, and after some time, if he is not, if there is no conclusion in the investigation, or if it is being dragged, you will enforce the court mechanism. Court will release. So there is a check and balance. There is a bridge between the two, and which provides an opportunity for a affected person to take. So that has to be there. So that is one thing I would say, that this advisory committee has a huge role to play. If they really want to play it, they have to play. They have to collectively, in consultation with the Attorney General, there should be members of the entire group, the forces, police, and then decide, periodically review. Because you know, the problem is, if a man is wrongly arrested and kept in remand even for a day, more than what is required, who is going to compensate? Who is going to take the responsibility? No one is going to take the responsibility. What about that individual's life? I am not, if he is implicated, yes, charge him, prosecute, on the evidence, let the court decide. But otherwise, don't abuse this law and take people. There is abuse and there is non-use also, as I told you. So the PTA, there is no magic in this. There need not be a huge hue and cry on this. It is a law dealing with a specific subject, that is terrorism. Terrorism is bad for a nation. In every country in the world where acts of terrorism, acts of similar nature are there, same provisions are there. Same detention order concept is there.
So that is, yeah.
Same detention order concept is there.
We haven't differed.
No.
Scenarios, yeah.
No. Only thing is, based on the structures of countries, the detention order issuing authority is different.
Yeah.
Detention order concept is there. But there is periodical supervision on the mechanism. Whether the investigation is being properly done, whether there is a delay, what about the rights of the individual? People also have rights now until you are convicted. Now, of course, the moment a person is arrested, he is convicted by the social media. Right? So, that is wrong. That is wrong. So, therefore, PTA is a law dealing with a specific subject. What is needed is provisions relating to enforcement. It is same to other countries. It's not a draconian law as people portray that to be. It is the same. You take the Terrorism Act of England and compare. Same concepts are there. What is wrong is what is the problem I see is the mechanism. If there is collective effort on the part of all the people who are involved, all the officers are involved, there won't be complaints of abuse. And people who have abused the law should be made to compensate. Then it will stop.
Right. A very comprehensive understanding there, sir. Just one small clarification and we can end today's discussion. This question on charges. Can an individual be kept in remand custody or within custody without charges within the PTA? How is that explained?
No, it's whether that is a problem in the legal system, because the final authority in drafting charges is the Attorney General. Now, in a case under the PTA, once you complete your investigations, you send the papers to the Attorney General. Now, we have an adversarial system. Our system is different to the United States. It can't be compared. Some people compare their rights in US with the people's rights in Sri Lanka. You can't do that. Because our prosecutors do not play an investigative role. They are not part and parcel of the investigation. Investigation is completed and sent to the Attorney General. The Attorney General will go through the papers and take time to draft. Nowhere in the law, whether it is a normal penal code offence or a PTA offence, there is a time frame for the charges to come out. That will be decided based on the complexity of the matter, the complex nature of the matter. You know, if now, for example, if I shoot somebody and kill him, and only one eyewitness, there is not a problem, you can straightforward case. But when conspiracy, terrorism, international terrorism, especially in the context, don't forget, especially in the context of high technology being used now, it is a massive investigation. So it has to be, I am not for a moment trying to say that charges should be delayed. Keeping a person in remand is not a punishment, no, it can't be a punishment, no. So, but only thing is, charges should be expedited. There is no mechanism, it is the same, but that is another matter that the advisory committee, in my opinion, should be looking at.
All right. A very comprehensive understanding given to us about the Prevention of Terrorism Act. Thank you so much, sir, for joining us in this discussion. The 25th President of the Bar Association of Sri Lanka, President's Counsel, Kalinga, Indatissa, once again, we thank you, sir, for joining us in this discussion. All right. The battle against terrorism is sensitive and important, as efficiency is of paramount importance. As it was made abundantly clear within today's discussion as well, lawmakers have made an important effort to fight terrorism through strict legal measures. At this standpoint, I would like to quote India's former permanent representative to the UN, Ambassador Rajiv K. Chanda, who once stated that we firmly believe that a policy of zero tolerance to terrorism is as much an international obligation as it is a commitment to our own people. Even though the government of India has been skeptical of the legitimate efforts undertaken by Sri Lanka in fighting the terror group LTTE, these thoughts by the ambassador resonate very well with the overall policy of Sri Lanka in not tolerating terrorism. Thank you for joining us on Law, Land and Liberty. Join us again next week as we bring another legal issue and break it down for our viewers' understanding. I'm Danny Dutanawasam. Have a great night.